By law, government must be open and accessible. Learn what constitutional law reveals. A review of important facts. Government is instituted to benefit the people and protect the rights of the people. The people have all political power, not government. The people have the power and authority to abolish government when it is not fulfilling its purpose. Constitutions are written agreements that outline what government officials must do and what they cannot touch, as in the Bill of Rights or Declaration of Rights. And I have done separate videos on each one of these topics, so if you have not already watched those, I highly encourage you to do so. But these are important facts that we need to keep in mind, and whenever you think of government, you need to know and have this cemented in your thought pattern. Government must be open and responsive. We all have equal rights. Declarations stated in one state's Bill or Declaration of Rights will apply to the inhabitants in all the other states. Government belongs to the people. It is the people's responsibility to keep government within its delegated functions. By law, the people have a guaranteed right to inquire into government operations. Government must be open and responsive to the people and the representatives of the people. Here is the New Hampshire Constitution, Part the First, Article 8. And the constitutions are fundamental law, which means it is the highest law in the land. Constitutions are written agreements and fundamental law, which means government officials must obey them. So let's see what it says. All power residing originally in and being derived from the people, all the magistrates and officers of government are their substitutes and agents, and at all times accountable to them, meaning the government officials are accountable directly to the people, we the people, and you and I and everyone else would be we the people. Government, therefore, should be open, accessible, accountable, and responsive. To that end, the public's right of access to governmental proceedings and records shall not be unreasonably restricted. The public also has a right to an orderly, lawful, and accountable government. Therefore, any individual taxpayer eligible to vote in the state shall have standing to petition the Superior Court to declare whether the state or political subdivision in which the taxpayer resides has spent or has approved spending public funds in violation of a law, ordinance, or constitutional provision. In such a case, the taxpayer shall not have to demonstrate that his or her personal rights were impaired or prejudiced beyond his or her status as a taxpayer. However, this right shall not apply when the challenged governmental action is the subject of a judicial or administrative decision from which there is a right of appeal by statute or otherwise by the parties to that proceeding. Now keep in mind that government is subject to statutes and the Constitution. The Constitution is the highest law. Statutes are inferior law. Here's another example where the state constitutions specifically address the people's right to obtain information. This is the California Constitution, Article 1, Section 3. Remember, this is fundamental law. It's the highest law. The people have the right to instruct their representatives, petition government for redress of grievances, and assemble freely to consult for the common good. The people have the right of access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. By law, the writings of public officials must be open, therefore redacting is in violation of law. And redress of grievances means to receive remedy for a burden, injury, or wrong done. So when our congressmen are asking for information from the Department of Justice and they get back paper that everything's blacked out, that's in violation of law because the public and our representatives have a guaranteed right to access that information. Here's another example In the Florida Constitution, Article 1, Section 24, wherein the fundamental law, the constitutional law, states that the people have right to access to public records. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf, except with respect to records exempted pursuant to this section or specifically made confidential by this Constitution. This section specifically includes the legislative, executive, and judicial branches of government and each agency or department created thereunder, counties, municipalities, and districts, and each constitutional officer, board, and commission or entity created pursuant to law or this Constitution. All meetings of any collegial public body of the executive branch of state government or of any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or at which public business of such body is to be transacted or discussed shall be open and noticed to the public, and meetings of the legislature shall be open and noticed as provided in Article 3, Section 4E, except with respect to meetings exempted pursuant to this section or specifically closed by this Constitution. Every American has the right to inquire whether elections and the processes performed were lawfully performed. Being a mayor of a city is just a job. The human being performing that job always has the guaranteed right to inquire whether any election was lawful, no matter which government position you once held. It does not matter what government role a human being is trying to obtain. Being one of we the people, they have the guaranteed right to inquire whether lawful form was followed for any election. We all have that right. If you were once president, you still have the right to question and look into the integrity of an election as one of we the people. President Trump has a lawful right as one of we the people to inquire into the process of an election, and he also has the guaranteed right of free speech to discuss anything he chooses. Every American, in their role as one of we the people, has the guaranteed right to question elections and also a guaranteed right to free speech regarding any subject they wish to speak about. Any government official or agency, whether of the executive, legislative, or judicial branch of government, must protect those rights. The Department of Justice and all judges as well. Free communication of thoughts and opinions. In the Arkansas Constitution, Article 2, Section 6, which is fundamental law, says, "The liberty of the press shall forever remain inviolate," which means it cannot be violated. The free communication of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their sentiments on all subjects, being responsible for the abuse of such right. In all criminal prosecutions for libel, the truth may be given in evidence to the jury, and if it shall appear to the jury that the matter charged as libelous is true and was published with good motives and for justifiable ends, the party charged shall be acquitted. By law, President Trump and anyone else have a guaranteed right to inquire and communicate their thoughts and opinions regarding election integrity. This is fundamental law, which is the highest law in the land. Breach of trust. Any government official or agency that does not protect an individual's constitutional rights commits a breach of trust and maladministration. Judges must abide by their trust agreement that states they will uphold and protect the rights of the people. Not to do so would subject the judge to a fine, possible jail time, and removal from position for breach of trust and maladministration of their duties. See my videos titled Constitutions are Trust Agreements and also Breach of Trust for more detailed information. Summation. Government is at all times directly accountable to the people. Government must be open, accessible, accountable, and responsive to the people and their representatives. The people have a right of access to governmental proceedings and records that shall not be unreasonably restricted. The people have a right to an orderly, lawful, and accountable government. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state. The people have the right of access to information concerning the conduct of the people's business. The meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. Any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or at which public business of such body is to be transacted or discussed shall be open. The free communication of thoughts and opinions is one of the invaluable rights of man. The people have a right to remedy for any wrongdoing done. Every American has these rights, no matter what position they might have served in government. Here's a maxim of law, which means a fundamental principle of law. Individual liberties are antecedent to all government. And antecedent means going before in time or preceding. Thomas Jefferson. He was a member of Continental Congress and also a signer and principal author of the Declaration of Independence, which was written in 1776. He said, "If we are to guard against ignorance and remain free, it is the responsibility of every American to be informed." It is important for each one of us to learn about our guaranteed constitutional rights and how our government was set up and should function. It's important for us to remember that we, the people, rule the government. The government does not rule the people. I hope this has been beneficial to you, that you have learned something new. I ask that you please share this video with others. Thank you.